Yes?
I beg to mention item number 6, my lord.
6. Huh?
Clearance field application.
Huh?
Learned people could just inform possibly lordship the case diary has not come, my lord.
Huh?
I am on interim protection, my lord.
Remember, sir,
6.
on 15th of May.
Mr. So-and-so appears for the petitioner. Learned APP has submitted that the case diary is awaited. Petitioner is on interim protection. List the matter again on 15th of May. Allowing the learned APP to requisition the case diary. Interim order passed earlier continues.
If you maybe.
Hmm.
I like to mention item number 1, lordship. We both sides have some personal difficulties. Other side counsel is senior counsel.
What does it mention? Why are matters mentioned? Do you know? Why are matters mentioned?
Next time will be called.
We'll take up your matter. Yes. Anybody else to mention? No. Ah,
Let to mention item number 20, 11.
11. Yes.
Call for, but see, I think receive. Sir, I have
CD we have received, but notice and not received. Notice not found.
We'll have to wait. Are you on interim? No. When?
15 on.
Your name?
Notice has to be served.
say hi.
A high. Mr. A high appears for the petitioner. Huh? Why your name is here in the cause list? You have signed the wakalatnama. Why should you appear on behalf of anybody? Huh?
Forget.
You forgot that you signed the wakalatnama. Mr. A high appears for the petitioner. Learned APP has submitted that although CD has been received, the service report on the respondent number 2 is awaited. Can we have it on an earlier date?
Then on
Who gave you the
12,
instruction,
12 or
sir?
13, 12 lordship.
Who gave you the instruction?
This person and the information all are the within the relative.
Accused and informant are relatives. When can we have it?
11, 12.
12th. List again on the 12th of May. Yes. Yes, madam. Hmm.
CD is not received. Service is also not published.
CD is received.
CD we have received, but
Service report is
have been
awaited. Same order, you go, huh? Madam, your name? FUC. Yes. Oh. Okay.
Decision 15, 15.
List again on 15th. 15th.
Delivery of order, item 15, criminal petition 1086, 2025.
Petition is allowed. Petitioner will be at liberty to approach the appropriate authority under the Customs Act for redressal of his grievance.
From here, item 14.
Hmm.
Of the same if I am be able to call for.
18/9 we have received the CD.
Huh?
18/9 we have received the CD.
Hmm. 8 and 9. She wants it taken up together with 8 and 9. Her senior will come. Okay. Next. এইটো 8 and 9 লগত মাতিব। Item 8 আৰু item 9 লগত একেলগে item 1 এইটো কিমান item? Admission to কি হ'ল? Admission to পিছত মাতিব।
Item 15. May it please your lordship. Lordship, in the same case, lordship, this honorable court has granted interim bail. That is why yesterday the coordinate bench has referred to this honorable court, my lord.
আচ্ছা।
The FIR is at page 10, my lord. Although the allegations are very serious.
But we allowed an interim bail.
Lordship, because this honorable court has perused the report. After considering the report, this honorable court has granted bail. The order of this honorable court will suffice, lordship, at page 17.
Anyway, lordship, POCSO is there, lordship.
You understand?
17 is the order passed by this honorable court. After perusing the reports. Perhaps the report revealed that the victim unable to recognize the accused person's lordship.
Who are you?
Lordship, I am
Just a minute. In that case, we had given bail to Aminul and Azizul. Just a minute. Aminul. Where is the SMS version? Aminul. Two Aminuls. But there, the service report notice was issued.
notice of.
Without service report, can we try it?
Lordship,
No, no.
Without a notice being issued to the other party, can we try it? Will not be fair, na? Because here we have only said that these two persons were not identified.
not that.
No, sir.
And the other who were taken into custody were also not identified.
Not-
Therefore, we had considered this. Now, whether we do not know whether these two persons were identified or not. How many are here?
10 accused,
Eh?
11 accused,
Now, how many are you before us?
9, my lord.
Accused number 9. So your name is there,
My name is there.
is it not? Yes, in the earlier case, number 2 was not there.
We cannot say whether he is being identified or not.
That is
That-
the
that
only
is
aspect.
lordship.
Otherwise, when all others are on bail, keeping him behind bars is not going to help the case in any way.
Sold. And so what has happened, lordship, the FIR on.
22 years old in these POCSO matters will not matter much because we are saying nip in the bud. Cut it when the tree has not grown. We'll stop him when he is young so that he does not become bold when he is old. Yes.
Order, lordship.
Some co-accused have been allowed to appear before the investigating officer to facilitate the investigation. Start this again on 21st of May. Okay.
16.
Yes, sir.
On the earlier occasion, my lord, when I approach your lordships,
Mm.
age 20, your lordship will find. On the submission of the state, that my lord, charges has been laid and I am not put up to trial.
Hmm.
Your lordship was pleased to close the case, my lord, as in
Huh.
factual. Now, my lord, I have made a categorical statement at para 5, my lord,
Huh?
that the police has made, my lord, search in my house on 21/3/26 after your lordship's order and 3/4/26. And my lord, also they are trying to apprehend me, my lord. And it has been informed that in connection with this case, my lord, they will arrest. Lord, this is, my lord, a high-handed action.
No, Lordship, maybe Lordship, because suppose Lordship, search sheet has been submitted and subsequently notice may be issued, someone may be issued to him, and if he is not appeared, then notice, he may be arrested on the basis of the court.
Is that,
We do
is
not
that
know
the
what is
case
going
that
on.
summons were issued and you did not appear?
Nothing, man. Nothing.
Huh?
No, man. Nothing. Suddenly they.
No summons till now?
No, man.
After submission of charge sheet, why is the police continuing the investigation unless something new has come up?
And
Maybe in some third case, his name is there, that he was
Yeah, I
also
think so.
connected in this case, some sort, that's all.
maybe in another case he is being implicated in another case only because of the police searching.
Okay, we'll allow him to appear in connection with.
Lordship, in 103 is there, Lordship, section 103 is also there.
Huh? What section 103?
I'll appear, my lord. I'll go for it.
Let the TCR come, Lordship. They have to, Lordship, with
Whatever
website.
my lord has to say, I'll say that. Say to them.
Without appearing the CD, Lordship, 103 is there, Lordship. Yeah, and this is AB.
Huh?
103 is there, Lordship.
So, you submitted a charge sheet.
Yes,
He was
submit-
not put up
submit-
for
submit,
trial.
Lordship, but Lordship,
He was not put up for trial.
he is being, he, in search sheet, Lordship, he may be shown as absconder because he has not
Hmm?
got any.
What is something on records, my lord? Get complete statement.
Please come to this page 20. Page 20. Petitioner has not been put up for trial. Do you see? Do one thing. There is a charge sheet. Yes, there is a charge sheet. Find out from the police station what was the charge sheet about. Ask them to send you a scan copy of whatever copy they have today. Today itself. Let them send it to you by email. The persons who have been put up for trial.
After some time, I'm
Huh? If he has not been put up for trial,
then Lordship.
then I will allow him to go and appear and find out why he is being searched.
That can be.
Huh?
Can it be tomorrow on Monday?
Monday it will be VC.
And Tuesday, Monday.
GC.
As far as lordship's concerned, I have some.
Otherwise, it will be on 18th. Otherwise, it will be on the 18th. No, he's not talking about second half. He's talking about this half.
Yes, yes.
He'll find out from the police station whether your name was put up for trial or not.
Right.
If our earlier order is wrong, say,
Right.
by some mistake, then we'll consider. And if actually you are not put up for trial, no question of arresting you in this case now,
Before one.
without warrants from the court.
Yes.
If there's a warrant from the court, it's a different issue.
Right.
What he was suggesting, maybe you did not appear there for the warrant. Yes, next.
All right.
After some time.
Fine.
All right, Bishop, item 1.
Yes, sir. What were you saying?
Council, they have some personal difficulties.
Other side counsel. Okay.
Yes, sir.
Today is the 8th. This court has been informed that the counsel for the respondents have some personal difficulty today. Accordingly, a prayer has been made for an adjournment in the matter. Full stop. Your name is?
A.S. Ali.
Mr. A.S. Ali appears for the petitioners. List the matter again on. When do you want it?
25th of May.
Huh?
25 of May.
25th of May. 25th of May. Is it necessary?
Yes, sir.
They have demolished your case in their affidavit in opposition, huh? What is the case about?
मतलब तो case is मतलब तो
Forged
yes, your lordship.
mark sheets.
मतलब
Yes, and how does a criminal petition stand?
मतलब it cannot say is that मतलब the report reveals that the मतलब the petitioner's petitioner's case is मतलब the
No, there was a forged mark sheet,
yes, registration.
huh? Registration, forged registration certificate of the SEBA. Of the SEBA,
Yes,
where
yes.
is it?
Petitioner claimed that मतलब that his registration card used by the मतलब petitioner. At the time when he मतलब appeared in the exemption 2010.
Just a minute, this page, which page? Page 20?
Report no can see the report.
No, what is page 20? Page 20 is the first document,
Page 20.
is the
मतलब, this is
registration
the
card.
registration number.
Awal Hussain, Nevaz Denai, Nevaz Devanai, okay. Namorgaon. What was the forgery alleged?
Only the registration number mandate figure.
Registration?
The registration number of the mandate informant
Hmm,
used by the mandate petitioner when he mandate appeared in the exemption 2010.
Lordship may peruse the page 62, my lord.
Report mandate.
62.
roll number so and so. How did you get your admit card? Your admit card is genuine.
Other all other documents in it.
He is registered as a student under the SEBA
Yes, madam.
from the school.
From the school.
From the school. Now the school gives you the school, the SEBA issues a registration
Yes,
card.
yes.
That registration number is again forwarded by the school in when he is appearing in class 10 examination.
Yes, yes,
School forwards it,
yes.
and then the
Mark sheet,
no, then the admit card comes,
admit card comes.
and then the mark sheets and all are
Yes.
issued. The registration number is wrong.
Yes. My lord, there.
What was his registration number
My
when
lord,
you issued the admit card?
My lord, registration number was issued in the year 2004, my lord, in the name of Mohammed Rukun Mia.
Now he must have a registration number against which the admit card was
Yes, my
issued.
lord.
What is that?
My lord, here kindly see our stand, my lord, at page.
You have seen, you have shown that the roll number is correct.
Yes,
Roll number is correct. He
Correct.
appeared in the examination.
Yes.
Everything else is correct.
everything correct, my lord, but
Hmm.
registration number was registered in the year 2004 in the name of Mohammed Rukun Mia. Used by the.
Very well. How did you issue him an admit card? That is
Yes,
what we are
ma'am.
asking.
My lord, here, my lord, we have stated, my lord.
Maybe you have printed the wrong card. We do not know. Yes.
My lord,
You are who?
My lord.
You are who?
I am the respondent number 2, my lord. I
Who
am
is the
Rukun
respondent
Mia.
number 2? Huh?
I am the informant, my lord.
You are the informant.
Yes, my lord.
How are you related to in this case?
My lord, what happened, my lord? This registration number is belong to me, my lord.
You are Rukun Mia.
Yes, my lord.
Huh.
This registration number belong to me, my lord.
Hmm.
The petitioner has never been a student, neither a regular student nor a private student, my lord. Even, my lord, this civil from the record, my lord, of the statement recorded under section 161 of the school headmaster of the concerned school, my lord, Amargaon High School, my lord. My lord, this petitioner is an employee of the center where the examination is being conducted, my lord. This petitioner.
Now
Might-
he is an employee.
At that relevant point of time, my lord.
Acha.
Yes, my lord. Might have, my lord, he know the loopholes of the SEBA, my lord, how a form preparation has been made, my lord. Initially, at that relevant point of time, there is no mechanism to detect, my lord. It is from the SEBA report. There is no mechanism to detect that this registration number is belong to that person, my lord. This person might have manipulated my registration number while he form his to appear in the examination, my lord.
Hmm.
He used my registration number as his registration number, my lord. So, my lord, against that registration number, admit cards been issued in his name, my lord.
Now, did you have a registration number at all
No registration number at all, my lord.
in the SEBA? What is
He
which?
claimed this is
Huh?
his registration number.
Ah.
This is a FR matter. He claim matter kindly see the
And since you have stated that this registration number belongs to this man,
Yes,
you must also have a registration number which belongs to this man.
yes, my lord. Regarding this, my lord, during the period of 2004, my lord, there was no digital provision for validation of data to ascertain the genuine.
I'm not saying that. I'm saying that this man's, you could trace out his registration card saying that this is the man.
Yes,
2004,
four.
Rukon Mia was the person registered. Now, do you want to say that he does not have a registration number at all
Yes.
against that roll number?
My appellant. Yes, petitioner, my lord. Yes, my lord. There, my lord.
He has an admit card.
My lord, the petitioner as well as the concerned head of the institution are responsible for using students' registration for,
What action against the institution?
my lord, they are at that relevant point of time, my
No,
lord.
no, the institution as such. Who did it? In the, that is not very
And
far off.
manual
Year what?
process-
What year?
Manual.
2010. These people may be serving. The headmaster must have forwarded it.
Yes.
What action against the headmaster? Have you lodged an FIR? This is not a criminal petition where we will see whether he should be prosecuted or not.
My lord, it is a matter of trial, my lord.
You are allowing, like they say in the Hindi movies, Magarmach bach raha hai. Crocodiles are in the water. You are cleaning the small fish. Eh? 2 or 3% lose their job over this. This scam will stop.
But our stand is that, my
Hmm?
lord, that time.
Have you de-recognized the school itself? That your school is doing this kind of things, you are de-recognizing. Some principal forwarded it. De-recognize the school. That this is the last batch of class 10 students we are taking in.
Due to such a problem, my lord, that cannot be detected, my lord.
But you can detect who had that registration number in the year
How,
2000.
my lord,
Huh?
after this, my lord, verification that has been seen.
So this admit card which was issued, with what verification it is issued? Tomorrow I can go and have another admit card issued for
No,
me.
ma'am.
Can you just tell us why should there be no trial or investigation?
So, my lord, since the matter of all are building matter. Before.
Which is genuine? Where is the report?
My lord, and
It will issue.
Who says your paper is very good? One person crosses the border and comes this side without a passport. Aadhaar card, voter card, this card, that card, everything there. He goes back or not? He has to go back. Admit card, attending the examination, marks, everything okay. Admit card was not supposed to be issued to you because you were not a registered student. So you got yourself a fake document which you produced. Unless you tell us, where did you get that document from? You must tell it. If you don't tell it, who faces the trial? You face it. If you say the school has given me this registration number, or where is the original of the registration? There is a serial number at the top.
My lord, as per him, he lost the original registration certificate, my lord.
So this is a duplicate one.
Yes, my lord.
You do.
initially law, duplicate matter issued, then was the matter.
Duplicate also lost. Sometime after that, duplicate was traced out, my lord.
So the duplicate was issued by SEBA. Duplicate is issued by SEBA. Yes, Mr. SEBA, how do you issue the duplicate when the original you cannot trace? We'll send it back for a fresh investigation, the person who issued the duplicate.
My lord.
Kind of a, the state is there.
My lord,
sitting
let the
there.
trial
He
may
knows investigation is not correct.
my lord, let the trial may continue, my lord. Court may, police may find some other materials, court may start, police may start further investigation, my lord.
Hmm.
This person is also mainly involved, this person, but my claim is only against that my registration number used by this person, my lord,
Hmm.
petitioner, my lord.
Hmm.
I lost an affair when I come to know that, my lord, though it is after the long time.
But I don't see why the trial should stop.
My lord,
Yeah? We'll take it up on next Monday. Not this Monday, next Monday. You are under some interim protection. Trial is
protection.
proceeding.
No, my lord, that is also, my lord, another thing, my lord. Even, my lord, we repeatedly approach the trial court, my lord, trial court.
Why are you approaching as an informant?
No, my lord.
How do you approach the
I
trial
have
court?
to-
Under what capacity you approached? You tell us that.
No, my lord, I am the informant, my lord.
So you approach the trial court by filing applications, petitions.
No, my lord, not application, my lord. We inform the through the PP, my lord. I assisting the PP, my lord. I can, my lord.
Where is the report?
Page 62, my lord.
No, this report it says that the registration card is wrong. What else is correct? And where is your duplicate? Next where?
So you can case.
No, registration card duplicate. Where is it? You have the original copy with you. You have the original copy with you. That you take, that ground you take there. Yes, by when will you file your so-called reply? Huh? You have filed it. You have filed it. Mr. Islam, learned counsel appearing for the petitioner has submitted that the affidavit in reply has been filed today and has paid for listing of the matter in the next week. Accordingly listed again on 13th of May, 12th. 11th of May, along with the affidavit in reply. এইটো সোনকালে পঠিয়াই দিব নহ'লে টেগ কৰিব নোৱাৰিব।
My lord.
Huh? Why? For a bill matter, someone else, huh? Huh? Yes. Have you appeared? Have you appeared before the investigating officer? You have appeared.
That city is awaited, madam.
This cattle that you catch,
My lord.
what about the chicken who are taken upside down in their scooters and motorbikes? Oh, they are birds, so cruelty to animals will not come in, huh? Is it so?
No, my lord.
Have you seen the condition in
Yes,
which
my
they are
lord, yes,
carried?
my lord. The very bad, my lord. Yes.
Hmm? But no one notices because it is not a bolero vehicle and a truck. It is a scooty. Learned APP has submitted that the updated case diary is awaited. List again on. When?
As per your lordship confirmation.
Updated CD.
Updated.
It is your convenience.
My lord, then, my lord. 18th, my lord.
18th of May.
18th.
Interim order passed earlier continues. See if that cruelty to animals contain birds
That's
also.
true, madam.
That word bird is there if it is.
That's true, my lord.
Item 5,
Item 5. Hmm.
My lord, the CD is awaited, my lord.
This is 480. Huh?
My lord, CD not received, my lord.
Have you appeared? You appeared. What was the allegation?
yes, something. Yeah, it is rough division between informant and transfer.
Hmm. Both the accused? Oh, the other lady. You are appearing for whom? Not for the lady. They should have come together when they want to stay together.
See a gap, man.
Huh?
See the first statement. As per me.
What is the age of the informant? Huh?
See
What?
the
This needs to continue. This needs to continue. Huh?
Short accommodation.
Because
Only, my lord.
there is no force in the relationship. There is a alleged promise and a belief of the promise.
My lord, interim protection he has, my lord. Maybe it may be.
Mr. M. Kolita, counsel appears for the applicant. The learned APP prays for an accommodation to produce the updated case diary. Petitioner is on interim protection. List again on 19th. 19th of May.
19.
Interim protection granted earlier continues.
item 7.
7 to 8, no?
Hmm? Hmm. Ah. 10. Long list.
We have received the,
In this instance, I am the accused, and the other case, I was the informant. In both the cases, the case are informant. In this case, both the cases, case are informant.
Hmm. And what is the other FIR?
It indeed. So what you will find, one thing very common in both the FIR is the jewelry shop. So in that very big started in the jewelry shop, for the going to the namaz.
They are diabetics, no?
No. So before going for the taking the rosa, they had both the parties.
When-
Who
when-
is going to take the deliver. Everything started from there.
Hmm.
We have received one CD, Lordship, the present CD.
What does it say?
Sufficient details are there. Co-accused eyewitnesses has implicated him. Other witnesses implicated him. Their injuries are grievous in nature. Fractures are there. Cut injuries are there. The person who
Enough and more evidence against him.
sufficient.
Custodial interrogation, why do you need it? Once you have enough and more evidence against him, custodial interrogation, why do you need?
Lordship, because Lordship,
Will he repeat it again?
maybe Lordship.
Huh? Yes, you are
I'm for the
paying.
informant, Lordship.
You are for the informant.
Informant, Lordship.
Yes, tell us.
Sorry, so I'm for the victim, Lordship.
Ah.
Azamuddin. So there is a grievous injury, Lordship. Fracture is there.
They also had grievous injury,
No, that is.
finger broken, dagger in the neck.
Yes, Lordship, that is there, but that will be clear by the another case diary, Lordship. Yeah. So, Lordship, there is a medical report also. I was undergone for surgery, Lordship. Fracture is there. This is a clear case of grievous heart.
Your medical report,
Page 20.
page 28. I think already punishment is there.
Both the parties,
Huh?
both the parties have learned their lessons.
Undisplaced fractures in nasal bone.
And the fracture on the tip of the left nasal bone, sir. Both the parties have learned their own lesson.
You have moved any petition for bail?
No, Lordship, I have no information.
You are not under threat of arrest.
Lordship, I have no instruction, Lordship, on that regard.
And the FIR they have lost, there is no attempt to murder.
We may not attempt to murder him there. Previous, sir, they're causing her. all this issue. Look, I have everything operated with the CDP of the. Well, there are allegations. They can find a charge.
You have the updated CD. You have the CD. Who has been identified?
Both
Who all have been identified?
Both 3%, three accused person.
3 accused. There are 5.
All 5 accused person.
Eh?
All 5 accused person. The next case is 3. That is right.
Next date?
Next case 8-9 is 3%, 3 accused person. It is 5 accused person.
Admittedly, they went to a shop. Both the parties assembled. Both the parties had their arms and
That is
this
also
thing,
there also in the city that they are.
stick-off. In the month of Ramzan, it is supposed to be peace and quiet all around. For jalebi, they are fighting. That is what the FIR says. I am not saying that. FIR says, where is that second FIR?
Page 9.
A dispute arose at the shop regarding jalebi. Take down. Take down. Heard Mr. J. Bora, learned counsel appearing for the petition, also heard Mr. So-and-so learned counsel appearing for additional public prosecutor for the state of Assam. The case diary in connection with Murajhar PS case number
30/26.
has been received. However, the case diary in connection with Murajhar PS case number 33 of 2026 has not been received. By the order dated 7/4/2026, the petitioners were allowed to appear before the investigating officer to have their statements recorded. It is submitted by the learned counsel for the petitioner that the petitioners have appeared, which is also reflected in the case diary available with the learned APP. Learned APP has submitted that there are that enough material has been collected. When the investigation has proceeded to a great extent, further custodial interrogation of the petitioners may not be required. petitioner should be available to face interrogation by the investigating authority as and when required. Yes. This court is of the considered opinion that the further custodial interrogation of the petitioners may not be required in view of the stage of the investigation. Accordingly, the interim protection granted on 7/4/2026 is made absolute during the period of investigation, provided that the petitioners appear as and when called for by the investigating authority, full stop. The petitioners will also not in any manner hamper or temper the investigation being carried out or try to influence any of the witnesses in the case, full stop. Any violation of the aforesaid conditions may lead to cancellation of the privilege of pre-arrest bail. Heard, Mr. Your name? R. Islam. Mr. R. Islam had, at the top you write, Mr. R. Islam for the informant had appeared to assist the APP. Huh?
R. Islam for the victim.
For the victim appeared to assist the APP.
Yeah, in this case, Lordship,
Hmm?
But Lordship,
Item 9 taken up first.
Before submission, Lordship.
Ah.
Here in this case, Lordship, one person died.
Hmm.
That PM report we have not received.
No.
That is required, Lordship, because otherwise.
How did he die? For
Because
death,
otherwise, other injuries are simple in nature. So, Lordship, that is required.
Just a minute, has been sent to the. But you have received the case diary.
We have received that PM report is not, we have not received,
Postmortem report is required.
not available.
What is the FIR?
Iman in Milot? Jelot? Two.
Hmm.
In the FIR, it is mentioned that there is a land dispute between two parties, but actual facts are such that I am not the owner of that particular land. I am in the cultivation of that particular land on a shared property. And I am not denying the fact that I was not present at the place of occurrence. I was not initially present, but I went there when the fight arose later on, and I tried to break up the. There was no malice from my side that I have some interest to attack the victim.
Your crops were standing on that plot of land?
Crop, it was not started, so, crop, have not started cultivation yet. I'm about to start the cultivation.
Are you on interim? No. Oh,
14 and 9 is B.
you are behind bars for 69 days. Huh?
The FIR is mentioned that, some weapons have been used, but from my position, nothing has been.
Your name is Kudrat.
On 15, Lordship may take up this method so that I can bring that PM report. That is
PM
required, Lordship, otherwise not. If PM is there, Lordship, if injuries are there, Lordship.
Person should not have died. In the earlier case, you have seen person did not die.
Hmm.
We could consider here someone has. You do not know. Do not know.
Otherwise, every witnesses are there, Lordship. 183 statements are there, witnesses are there, Lordship. Everything, other
15th
materials are
will-
there. So only to look into the matter.
This is 15th and other one, item 8.
This is 14, Lordship.
No, this is item
14.
item 9.
I know what I was.
Item 9. Item 9 and item 8. You are collected. Kudrat and Saiful will await the PM report. And what about item 14? Who appears? You appeared. Yes. No, item number,
40.
item number, this, eight man. 8, who appeared in 8? You are appearing for 8. You are named. You are named in the FIR, but you are not arrested. Huh?
And the younger brother of item number 9.
Udrat.
A picture is good. Here is what the only contention is that when two parties were having a quarrel among themselves,
Huh.
which I have provided to the case, yes, trying to do the shareholding options we cultivate in that particular land. We were trying to separate both the parties. The state interest that I will either attack any of the parties. My only concern is with the brigade. Now, after that, both the parties, someone has hit each other and then one to other well, and the course of this transportation to the hospital case. Here you not be my role as an attacker is not available in another Kudros coaching. I, as the brother of Kudros, I was present at this particular spot. But there is
Anything against this Ijjat
Asan,
in that city?
Suppressing materials.
Even,
Materials are there.
against Ijjat also? Okay. We'll await the PM report, have it on the 15th. Let us see the how he died. Only because he died, otherwise.
Otherwise, I am submitting also. Other materials are simple. Other injuries are simple in nature.
Simple in
So also that is why
If it is
PM
a, if
declared
it is
also.
a kick to the chest, different issue. If it's a blow to the neck, a different issue. Then it will become
That will be
34.
looked into by the
34.
trial court also. That who
34.
has implicated.
Earlier 34, now what? Common, huh?
3-5.
List again on the 15th of May, allowing the. Huh? We are awaiting the postmortem report. It is after that we'll go to the CD. If we are there, let us assure you, we'll go to the CD to find out if any role has been assigned to any one of you. We'll not have anybody and everybody behind bars. Who is that man? You are behind bars at this point. 15th. If you are behind bars, let it be till the 15th. Heard, Mr. Your name? Item number 8, who appears? Your name? T.L. Oscar. In item number 8 and BA number so and so. Mr. In item number 9. And Mr. Your name? Your name? Huh? S. Ahmed. In item number 14. Huh? List the matter again on 15th of May, allowing the learned APP to procure the postmortem reports. A postmortem report. Full stop. If not the entire report, at least have the opinion of the first medical done. Oh, he died on the way to the hospital. It has to be a postmortem report. He's awaiting the postmortem report. 15th.
10.
Huh? CD has, this is the GST. Huh? Hmm. Yes.
CD is awaited, my lord.
You don't need to.
My lord, there is.
List again on
19, my lord.
full stop. The learned counsel for the petitioner, your name? And then one has submitted that the petitioner is, no, that on the earlier occasion, this court had directed that no coercive action to be taken against the petitioner. Full stop. List again on so-and-so date. Interim order passed earlier to continue till then.
Obliged.
16.
Yes, sir, any information?
No, see, and he was supposed to send me in the CS, but he is not at the police station, so he's trying, but it
Huh.
will take some. But as per his instruction, now he informed me that his name is there in the CS.
In the charge sheet it was there.
That is why he's told me that, and he is the prime accused as per his statement now. So can it be on 14 and 15 or so? I will bring that charge sheet.
Even if his name is there in the charge sheet, after submitting the charge sheet,
Even and in that case, also, he has also told me that he has no police has been sent to his home. It is his he informed me, Lordship. I do not know what is his. He told me that no, but his name is there in the CS.
There are five, and we have given the dates also. Search has been made inside the house. Categorical statement, these are not vague statements.
your name is Joinul. By when can he send it? He is not here in the afternoon.
I can bring it on 11 also, Lordship, next Monday also, Lordship.
But if it is next Monday, then
But it has to.
the earlier order is passed by me.
Fine, your lordship is aware, there are before judgment, Bharat Chaudhary.
Ah.
Well, some protection can be done because.
No, once the charge sheet is filed, what authority do you have to arrest him?
I do not know, Lordship. That is Lordship. That is Lordship, because now if that is being allowed, that protection has been given to him, then if he is being made absconder in the search sheet,
No, we'll make.
then that will be protection for him also.
No,
Lordship.
no. We will say the police would not, he would not be proceeded against by the police without an appropriate warrant of arrest from a competent court of law.
Or without any someone from without any warrant.
If there is someone you are not authorized to arrest,
And
we will say in the
Well-
meantime, he would not be arrested without a warrant of a proper warrant, a warrant from a competent court. Get a warrant, arrest him immediately. But without a warrant, don't arrest him. It cannot be for investigation. Are you authorized to arrest someone
No.
in a charge sheeted case?
No, no.
And I am asking the law, I'm. But
Once
in a
it is
charge
said
sheeted
and
case,
submitted.
can you arrest a accused? You cannot. Unless there is a warrant by the court that I need
Because
this
those
man.
matters subjects before the trial court.
So it will be now their prerogative. So we can just observe that since a statement was made on the earlier occasion that the
respect
matter
of-
has been charge sheeted. That the matter has been charge sheeted and the petitioner has made a specific statement that the police is looking for him. The petitioner would not be arrested without warrant from a competent court of law
And in respect of this case, only
in respect of this particular
present
case.
case.
That will
That can
do.
be done.
That will not harm
That
the.
will be done.
Heard Mr. So-and-so. The counsel appearing for the petitioner also heard the learned APP. On an earlier occasion, the petitioner had approached this court by filing AB number 257 of 2026, where by the order dated 9/3/2026, this court had observed that the 9/3/2026, 9/3/2026, this court had observed that the charge sheet in the matter had been filed being charge sheet number 1 of 2026, dated 6/1/2026, and that the petitioner had not been put up for trial. Accordingly, the anticipatory bail petition was closed. However, Today, the learned counsel for the petitioner has drawn attention of this court to the contents of paragraph 5 of this anticipatory bail petition, stating that the police have been conducting raid in his house and trying to apprehend him in connection with Hailakandi PS case number 133 of 2025, corresponding to GR case number 421 of 2025. The learned APP has submitted that the search for the petitioner, if at all true, may be in connection with in connection with his with some warrant issued against the petitioner in the trial proceedings or in connection with some other case pending against the petitioner, full stop. In such circumstances, he has submitted that giving a blanket protection to the petitioner may not be proper at this stage, full stop. Having heard the learned counsel for the parties, this court is of the opinion that the learned APP should be given an opportunity to verify from the concerned police station as to whether the petitioner is actually being searched for, and if so, in regard with, in connection with that, and if so, the case in which such search is connected to, full stop. In this matter again on 18th of May 2026, allowing the learned APP to have his instructions. In the interim, it is provided that the petitioner shall not be arrested in connection with Hailakandi PS case number 133 of 2025, corresponding to GR case number 421 of 2025, without there being any warrant of arrest issued by a competent court of law. Stop. List as aforesaid.
Item 3.
Yes.
Second.
Ah. Mm-hmm. Ah. 2/8/23, 6/8/23, and arrested on?
6/2025.
Why it took 2 years?
Is seeking the order. Thereafter, the charge sheet.
What was the FIR? To pray in the temple.
Informant হলো মই কাটকে কইলো তখন মই কম
হ্যাঁ। Page 15 I have read. Ground of huh. Just a minute. In the evening, just a minute. Allow me to. Huh.
Charge sheet file charges with the witnesses. Around 4 witnesses already examined. Those who had
And thereafter, after the finding of the incident, is possibly another one is where it was examined. Here was the option has when I give my lot during that partition and that part of them. There are three model.
Page?
Case 35 model, there are three model.
Ah. Page 35, para 3, huh? I am not convinced, huh?
On the merit method, otherwise, there is a life of intention because we didn't custody for around 8 months, 17 days, there is around 321 days in custody. And also rejected is on around 15 or 25. There are 4 months, 21 days, there is around 142 days back it was rejected. And here are most of the mental weaknesses matter. Already examined.
Who all have been examined?
Her father, the informer, the medical officer, there's a father and the. There are some equity groups, they can provide ways to. She can consider a record.
Where is the statement of the victim? Huh.
Something that's kind of others is
Does the father say?
there were FIR, he says that they were made to have something like that.
Ah, no, what are,
They say,
hmm.
that part matter. Subject to correct possible, victim, neither the victim nor the.
Victim may say that, may not say that.
Other also did say.
Huh?
Other also. Right. That is space 30 to the margin.
No, in the FIR they say about the water, here they don't say about the water, no?
Others, they also possibly because say.
What kind of a father is this?
Other also because say.
No, what kind of a father is this?
Well.
3 people unrelated to him come to his house.
Well.
Page 23.
Well.
Look at page 23. Para number 12. What kind of a father is he? And then in the same room, there is the mother.
Well.
And the child is attacked.
Well.
By one of them, thrice in the night.
Well. Possibly because of that water, my lord.
Which water?
That-
Where is that water? Show us.
No,
The
well, in the
statement?
FIR, it is.
In the statement.
Well.
FIR is only to contradict,
my
not
lord,
to
I
contradict.
understand.
We'll go by the statement on.
My lord, but possibly.
Now, who drinks the water? Please see who drinks the water.
No, mother and
Page
this-
23.
mother and father possible.
No, page 23, top of the line. Please see. Top line, what does it say? Who drank the water? Huh?
It's 23.
Who drank it? Yes, Mr. Bush, who drinks the water? Who? At page 23, top line, who drinks the water? Child. Who keeps sleeping when this man is ravishing her thrice in the night? The mother. What does the father do? Strangers, daughter, wife, along with the strangers in one room.
That part is there.
Hmm.
That part is there. Man.
And then in the FIR he says, I drank the water. Here he says, my daughter drinks the water. Who drinks the water?
But my lord, the earlier order passed by your lordships, my lord, it was passed after perusal of the statement of the witnesses, my lord, annexed now as on today. So, my lord,
No further witnesses have been examined.
possibly not, my lord.
Now, 2 days after the incident this has happened,
My lord,
the FIR was lodged.
on 6/8, my lord,
Huh?
after 4 days.
4 days. Page 27, serial number 1. Tell us, you have to, if you want to object to the bail, you have to fight it back.
My lord.
If you want to object to the bail, fight back.
No, but that is why I am submitting, my lord.
So page number 27,
Yes,
serial
my
number 1.
Well, after 4 days, there will not be any sign of sexual intercourse. That is apparent. Now,
So water drank by the child, mother keeps sleeping.
my
Not once, but thrice.
true. And
FIR lodged in a point of time when you cannot have a medical examination done.
Ground, my lord.
Huh?
Taking the opportunity of puja, my lord, he is Ohed Ali. He pretended to be a tantric, my lord.
Come to page 29.
My lord.
What does the father say? Mother and child and the 3 strangers in one room.
My lord.
Now see what the victim says. Paragraph 4.
No, I have seen, my lord.
What?
I have seen. I have seen, my lord. Another thing, my lord, possibly because the
And then this water comes from the father.
my lord,
The father says she is drinking water.
my lord,
And what does she say?
my lord,
Paragraph 5.
my lord.
Then please see 15 at page
Serial
31.
number 15.
Page 31.
Because of this 15, my lord, earlier occasion, I was also there, my lord. Because of this 15, lordship rejected the bail prayer. With all respected forbearance. Because
Now,
I had,
that's the second
My lord.
paragraph of 15.
my lord, no, no. On last occasion, my lord, because of 15, my lord, I can remember distinctly, my lord.
Here are reported cases that foundation fact has been proven.
True, my lord. Lordship will kindly see, my lord. FIR came to be lodged
In any case, now this was recorded when 29th of December.
my lord. FIR was registered or lost in the year 23, my lord. Kindly see the date of arrest of the, my lord, this person. That is why after 2 years, for 2 years, my lord. Because lordship's earlier order was passed after perusal of the evidence of this victim, my lord.
Hmm?
Lordship's earlier order was passed after perusal of the evidence of the victim.
This stage. All respect, my lord, there is no. Discussion, my lord. No.
But nothing new has come up. Nothing new has come up. What is the new circumstance?
Others. Others everything.
No, that is prior to the order. 18, 12,
25 is the date of order, my lord.
Hmm? Victim done, father done, mother done.
My lord.
Medical. How many have been examined? 4.
5 numbers of witnesses
Huh?
examined, my lord, as per the record, my lord.
5.
PW 5 is examined on 2nd on February.
Just a minute.
26.
How many examined? 5.
My 5 number witness examined. Today, my lord, 11 numbers of PWs are there, my lord.
11 numbers of PW would be there. Who are the people? Those who will say,
IO will be there, my lord.
all who had heard, IO will be there. IO will have no fear. And
Police witnesses, my lord, 2 numbers of witnesses. Otherwise, medical witnesses examined, my lord, that is the victim, and my lord, the father and the mother already
the
examined.
majority of the relevant witnesses
Yes,
who may
my
have known about
One
the
is,
incident
my lord,
gun,
Boro, my lord, whose name is second.
Roman Boro.
Roman.
Ah. He will say, yes, we went there and I slept the night there.
That otherwise, my lord, other than.
Other there are no
prosecuting
others.
and the, my lord, that is the crime scene, my lord, that is the, my lord, mother and father, nobody is there. One statement says that, my lord, that is in the room, my lord, where the.
How many days you are behind bars? You were arrested on 22/6/2025.
My lord.
And you are a resident of what? Which place? Nalbari. And the crime is committed here at Kamrup.
Gorchuk, my lord. Gorchuk. My lord.
Yes, what is your fear now? You have given your statements, everything done.
Fear is this, my lord. For apprehending him, it took 2 years.
Uh-huh.
During investigation,
Ah,
for his arrest, it took 2 years, my lord.
if he flees away. That is the PP's ground. You tell me your ground.
My lord, that is the ground because justice is to be done to the victim, my lord.
We'll put on conditions which will ensure his attendance.
My lord,
Give us a ground where he should continue behind bars.
my lord. I leave it to lordship. my lord.
Otherwise, my lord, already, my lord, gone through there is the victim statement. See, in her seat, my lord clearly implicated the person. Only that part is there, but my lord had
But
pointed.
the difficulty is that the parents are saying
My,
she was in the same room.
my lord. And 3 times.
Mother is saying
Omission of 3
different room.
My lord.
Is it not? Medical report says recently there is nothing.
But it is after 3 days, my lord. Medical
Hmm.
part is different.
Where is that medical report again? Medical report, is it available anywhere?
My lord, the medical report is there, my lord. Only, my lord, that is,
Wait.
my lord, submitting from the, my lord, that is the depositions of the, my lord, doctor, my lord.
No, here the deposition of the doctor is there.
Yes, my lord, that is
The
there, my lord,
25, my lord.
page 20.
5.
Starts for 225.
Hmm.
27.
Age is according to the 16 to 18. Hmm?
But certificate is there.
No, birth certificate exhibited, my lord.
16 years.
About 16.
That from
date of birth. I thought that is 3 to 7, and at that point of time, what my learned senior colleague completed 16 years, 5 months and 11 days. Below 70.
Below 70.
Below 70.
We'll allow it with strict conditions, otherwise. At that time, the mother's part had not come in. She is also wavering. She had the time, but yet she is wavering. What to do? But Mr. Chaudhary Learned Counsel is paying for the petitioner. Also heard your name, sir?
NZS.
Mr. Bush appears for the
Respondent
as the
number-
APP for the state. The bail application of this petitioner had been earlier rejected by the order dated 18/12/2025. Stop. Since some progress in the trial court has been made by examination of witnesses after the aforesaid date, the petitioner has again approached this court by filing this bail petition under Section 483 of the BNSS 2023 in connection with Session Special Case Number 123 of 2025 under Section 376 IPC, read with Section 4 of the POCSO Act, pending in the Court of the Special Judge POCSO, Kamrup, Gauhati. The Learned Counsel for the petitioner has drawn attention of this court to the different statements of the PW number 1 to PW number 4, which have been annexed to the present bail petition, and he has submitted that the PW number 5 has also been examined sometime in February
My lord, it is
2026.
on February, my lord. 2nd February, my lord.
On 2nd of February 2026.
2026.
He has submitted that the statements of the victim, the informant, the doctor, the mother of the victim have been already taken on record. Full stop. The Learned Counsel for the petitioner has submitted that since the trial has proceeded to quite some extent and the petitioner has been behind bars for 321 days as of today, this court may consider the grant of the privilege of bail to the petitioner since he undertakes to abide by any and all conditions imposed by this court and also to continue to participate in the trial proceedings without fail. Full stop. Mr. Busho, the learned APP has submitted that on the earlier occasion, this court had gone through the statements of the witnesses recorded till that date and was of the opinion that the court was not convinced that there was little or no chance of conviction. Full stop. Accordingly, he has prayed for dismissal of this petition. Mr. Ali appears for the informant, has submitted that the petitioner had been absconding during most of the investigation period, and there are chances that he may again avoid trial, and therefore the bail petition may be rejected. Full stop. I have heard the Learned Counsel for the parties. Keeping in view the length of detention of the petitioner and also the fact that the prime witnesses have already testified, now there being little chance of the accused causing any hamper or temper to their evidence, which has already been recorded, and this court is of the view that the petitioner can be granted the privilege of a bail at privilege of his bail at this stage. Full stop. Accordingly, it is directed that the petitioner shall be released on bail on punishing a bond of rupees 30,000 with two sureties of the like amount, subject to the satisfaction of the trial court, comma, where one of the sureties, where at least one of the sureties shall be a government servant, and at least one of the sureties should have immovable property within the jurisdiction of the learned trial court. Full stop. The learned trial court shall be at liberty to impose such other conditions as it may deem fit to ensure the participation of the petitioner in the remaining in the remainder of the trial. Full stop. It is made clear that that the petitioner shall not in any way try to influence the remaining of the trial or any of the witnesses who remain to be examined. And in case any violation of the conditions imposed upon the petitioner is brought to the notice of the trial court shall be at liberty to recall the bail granted to him.
As because, my lord, that is the.
Bail application is
writs
disposed of.
matter is, my lord, submitted. As my learned friend, flight writs matter is submitted, my lord. So may I
What?
make, my lord, that is, he may plead away, my lord.
Ha.
That, my lord, submission is made, my lord. So, my lord, in this regard, may I pray one thing, my lord, that is one condition may be given, my lord. If he will not, my lord, appear, my lord,
Ah.
his counsel or that, my lord, that may be.
The petitioner, it is further clarified that the petitioner shall continue to appear in the trial proceedings as and when required by the learned trial court, and his absence on any date fixed by the trial court may be considered by the trial court. Full stop. The absence of the no, in case of absence of the petitioner during the trial proceedings,
Without any steps, if he not through a counsel, he is not.
the absence of the petitioner in the trial proceedings, comma, if any, unsupported by sufficient cause, shall be the learned trial court shall be at liberty to that condition we'll put in. I'm not being able to frame the sentence. Something else is in my mind. I'm not getting that sentence proper. Absence of the petitioner in the trial proceedings without sufficient cause being shown. Yes, we'll put that condition.
Obliged.
Sorry to inconvenience your lordship, I mean, just remember, there was one matter, that withdrawal of the resignation.
Yes.
But that, there's a development. What has happened is that, the petitioner's staff loan, he had a staff loan, when he was an employee, that they have turned NPM. Because the amount used to be deducted through the salary. Now, last 1 year, he has no salary, contested. So the other apprehension of mine is that, the matter, I hope that it is because, the Supreme Court says that within 3 months,
Otherwise, it is ready. We were just trying to find out the relief that can be granted. Otherwise, we have found it to be incorrect.
in fact, lordship had more or less dictated the order in court. So, nothing remains, only to be put on pen and paper. I'm sorry to be informing in this manner, but I think next week lordship may not be at the principal bench.
So that will not hamper it. We can have it even through, because it is just for delivery of orders. We can even have it through this thing. Heri ketia asile to? Ketia asile CAV?
It was on 24/2.